And it's usually very easy to do if you actually sort it out. But if you don't do it and the business takes off, you can be sure that an ownership dispute will be messy. If we can come around to see you and see some kits, we love that. I mean, we're all engineers, really.
AI cannot be an inventor. An inventor has to be a human being.
Welcome back. We're incredibly fortunate to be joined by two experts from Venner Shipley, Gary Whiting and Rob Cork. They're both European and UK patent attorneys and partners in their electronics, software and communications team. They both have extensive experience advising a wide spectrum of clients, from spin-outs to large multinationals, and helping businesses secure and defend their patent rights across complex technological fields, including software, telecommunications and satellite technology. Gary, Rob, welcome. Let me start by asking you, Gary. Our community at Surrey Research Park and in the wider ecosystem includes a lot of startups and also many SMEs who are rapidly developing new technologies. In your experience, what's perhaps the most overlooked but critical first step that entrepreneurs should take to protect their core innovation, even if they're just in the early stages of development?
Yeah, I think particularly in the very early stages, I think people wear a lot of hats, and they're maybe working with lots of different organisations. They might have a spin out but working elsewhere. They might be an academic, all that sort of thing. So actually who owns intellectual property can be tricky. So I think that was always my advice. You know, make sure that if you want the company to own the IP, which you probably do, make sure that is what's actually happening. And it's usually very easy to do if you actually sort it out. You know, a simple agreement, one-page contract does that. But if you don't do it and the business takes off, you can be sure that an ownership dispute will be messy later. So yeah, I think that would be my one. And it costs almost nothing to sort it out as well, which of course is great news for people.
Definitely.
So, yeah.
And when should they turn to an organisation like Venner Shipley in that process to, how early is too early for the new entrepreneur or the new inventor?
I don't think there is a too early. I'd say come talk to us today, particularly if you're on the park here, because I mean we spend all our time with PowerPoint presentations and bits of paper and things. If we can come around to see you and see some kits, we love that. I mean we're all engineers, really. So I would say probably what people want to do in the early stages, they want to answer the question why. That's an overlooked question in IP. Why are you doing it? Why do you want a patent? Why do you want a trademark? So to answer that question, you need some sort of strategy, IP strategy. You know, a grand term, but it can be very simple. We can help with that, and we don't necessarily even need to charge for that at the very early stage. So if you're early on, thinking about how am I going to make this fly, how am I going to make this work, how can IP help me? Well, we can have a chat over a coffee and do that, for nothing. And then when you are ready to file patent applications, then you can come back and talk to us again.
Excellent. And just turning to Rob here, earlier we had a conversation with our expert in AI from the University of Surrey, Andrew Rogoyski. And obviously AI is becoming much more prevalent and it's also becoming much more powerful. It's involved in everything from writing code, generating designs and new imagery. But what are the biggest IP pitfalls for businesses in particular when it comes to using AI as part of their development process? Who actually owns the IP if it's generated by AI?
It's a great question. Very topical. Someone asked me that just this morning, actually, over at the marquee at the event. And I think I'll answer the second question first, I think. Who owns the IP? So ownership comes from the inventor. So you have to work out who the inventor is, first of all. And then you would look, for example, at who is the employer of the inventor. Are there any contracts in place? That's when you're dealing with humans. The courts, whenever they've been asked to look at this so far, I think, not just in the UK, but in other countries as well, have been very clear that AI cannot be an inventor. An inventor has to be a human being. And it's similar, I think, for copyright, for other types of IP. So don't assume that if you're creating something using AI, that the AI can be an inventor and the only inventor. You need to be able to name a human as the inventor, really. that's not in itself too problematic. I mean, it's perfectly common to have teams of inventors, co-inventors, human inventors. And I think if you think about how we use AI, imagine yourself going through the same development process you've done with AI, but instead of putting the prompt into your AI algorithm, your ChatGPT, you'd given that question to a human collaborator. Was your level of input there enough to make you an inventor? If the answer is yes, forget about the AI, you're an inventor, fantastic, you can protect it. So I think in terms of pitfalls, it's making sure you document that whole process. How are you using the AI? What prompts are you giving it? What are you asking it to do? And then when you get some output from it, what are you doing with that output? Are you iteratively refining it? Document all of that because you might need to answer those questions in the future.
Great insight. Thank you so much. And obviously, we talk about the pace of technology moving. We had, again, from the poll that we had with Andrew earlier, it highlighted the fact that regulation is struggling to keep pace with where technology is getting to. How do you think the legal frameworks need to evolve, really, to keep pace with these revolutionary changes?
So I think looking at the long term, this is the 40th anniversary of the Research Park. Where will we be in 40 years' time? I think it's not hard to envisage a situation arising where 90% of the value, the commercial value in a product, comes from features that have been generated by AI, and you need to have some way of protecting that. I think where we are at the moment is it's in its infancy, people are using it, but I think most of the commercial value in a product is probably still, for most products, tied up with features that can be protected by existing IP. But as I said, an AI can't be an inventor, so I think the law is going to have to evolve, whether that's by allowing AI to be an inventor or whether it's by maybe creating an entirely new form of intellectual property. We don't know, but it'll be interesting to see where it goes.
Brilliant, thank you. So here's an interesting question specifically about the creative industries. The creative industries are one of the UK's biggest exports. How do we ensure the value of creative IP isn't lost in the age of AI?
So in terms of protecting it, I guess, are we thinking about, it's all been in the press, hasn't it, with actors, famous actors, for example, their likenesses, their voices being imitated. I think it is a problem. You're sort of getting into the realm of copyright there, and I think that's a question that the legal system is grappling with at the moment, and we don't yet have a clear answer, but I think it's something to keep an eye on and be aware of. If you're putting information out there in the public domain, is that going to be picked up and used to train an AI that you don't have control over? I think that's the biggest thing to be wary of. So if you can, make sure you're keeping ownership of what you're putting out there.
Fantastic. I suppose from my side of things, and because we've been talking very much around entrepreneurship, you've just followed on from Chris Hobbs, who was here earlier. What would you say would be one key piece of advice from each of you that you could give if you could talk to somebody that's an inventor directly? What's the one takeaway message that you would like people watching this to really go away with today?
I think it's to understand what you're doing and why. Right at the outset, have a plan. For example, if what you're trying to do is you're trying to set up a proof of concept, get something to work, and then sell it on, then you probably need a good patent portfolio because that's going to be what you're selling. If what you're doing is you're generating lots of products, you're going to get into the market quickly, you're going to sell them, and then you're going to move on to the next thing, well, maybe you don't. So understanding what you're doing and why, and then being focused on that.
Yeah. I think as patent attorneys, two of the issues that we grapple with on a day-to-day basis are what we call novelty and inventive step. That's the basic requirements for an invention to be patentable. It has to be new and it can't be obvious. Don't get too hung up on the second part, obviousness. I think a lot of people, you find, that they're reluctant, I think, to come and talk to patent attorneys or to look into patenting because they feel that what they've done is obvious, it's simple, it's not something that would merit patent protection. That threshold is much lower than most people would think. I think if you've got something that's new and it solves a technical problem, there's a very good chance that it's patentable. So if in doubt, talk to a patent attorney. We're always here, we're happy to help.
Excellent. Thank you. Fantastic insight that we've been able to share today. So really appreciate it. Rob and Gary, thank you very much.
Thank you.
It's a pleasure.